Here number 13, Ram Bhagat Singh Bhagat versus the state of Bihar.
May I please, Lord? Lord, this is the second round of litigation. Lord, I am giving the list of dates. List of dates.
Is here.
Lord, a detailed, that would be more. Lord, the charge memo which is at Annexure 8 was issued on 17/1/89, my lords. The petitioner filed his reply. The inquiry, in the earlier inquiry, my lords, he was partly exonerated of some of the charges, my lords. Then, my lord, second so-called.
What is meant by majority of charges?
My lord, there were two charges.
No, majority. What is the word here? Majority. Do you know meaning of majority?
Large number of charges. It may be, he was exonerated of some of the charges, my lord. It may be read like that. He was exonerated of some of the charges. My lord, second so-called notice, reply filed, there was order of dismissal was passed. Filed a writ petition, my lord, it was dismissed on the ground of delay and laches. Then he filed an LPA, it met the same fate. He appealed to the Supreme Court, the order was set aside, matter was remitted to the division bench, LPA for deciding it on merits. The LPA bench order is very important, my lords.
LPA was?
My lords, the LPA which was earlier dismissed,
It was restored.
it was restored by the virtue of Honorable Supreme Court. And the LPA bench, my lord, set aside the order of dismissal and made a limited remand, saying that on same inquiry report, you pass a fresh order because he has been exonerated of some of the charges. Tentative, what, my lords, thereafter, my lords, they issued a fresh charge memo.
Now, where is this LPA order 1078 of 2000?
Annexure 23, my lords.
Next, sir?
Annexure 24 at page 116 of my lord's brief. May I read it? In our view, there is non-application of mind to the disciplinary authority while passing the order of dismissal. In that view of the matter, the impugned order dated 20th July 1996 is set aside, and the matter is remitted to the disciplinary authority to consider the matter afresh, taking into consideration the contents of the inquiry report. The result, the appeal is allowed, and the order of the learned single judge dated so and so.
Have you challenged the charge memo?
Lord, earlier I have challenged.
Have you challenged the fresh charge memo dated 6/11/2000?
Yes, my lord, but my lord was not inclined to allow that IA on the ground of delay and laches. That my lord will find on the last order, my lords. But what I will submit, my lords, as far as the fresh charge is concerned, the order of remand, my lords, is to be seen whether the authority has transgressed the limits put by this.
Filed contempt.
My lord, I will not go into that. My lord, I will, my lords, on the merits I will argue. Let that point be. If my lord is not in.
So you will admit fresh charge memo sustains because you have submitted your explanation that you have surrendered your rights.
My lords. My lord, surrender your right, my lord. To that, my lord, submission would be waiver, acquisition will apply, my lord, against statutory law.
Then file contempt.
I will not go into that, my lord. I will go into the merits of the case. Why should I, my lord, go into all those things? And, my lords, thereafter, my lords, they initiated a fresh inquiry. My lords, no document was supplied. That is an extra 35. It does not contain, my lord, list of witnesses. It does not contain, my lord, list of documents.
Where is that?
That is with the IA which has been rejected. IA, my lord, has rejected it. That has been enclosed with the IA.
Insofar as challenge to that, it has been rejected.
My lord,
where have you produced this charge memo?
Annexure 35, my lords. That is with the IA. IA number 1, my lords. Annexure 34 is the charge memo. in the first inquiry, my lords, 3 witnesses were, their written statement were recorded, were produced by them. They were not examined in course of inquiry. They were
What is the date of document Alleger 34?
34 6 11 2003, my lords. 3.
3.
3. Then, my lords, my reply was taken, and then in 7/1/2004, my lords, one witness, Uday Sankar Chaudhary, he filed a written statement in support of the charge. He was not examined, nor an opportunity of cross-examination was provided. Violation of 17(4), my lords. Again, another witness, his written statement has been brought on record, and he was not produced on any day in the inquiry. And then, my lords, a report was called from the district manager, and then another witness, C.R. Jha. 3 witnesses were examined in subsequent course of inquiry, my lords. And, my lords, thereafter, my lords, petitioner filed an application for supply of document. It was not given. And then after, my lords, a final. And what is more important, my lords, most important thing is, in the previous charge, my lord, I was exonerated of some of the charges. 556, it is alleged that there was misappropriation of 5,56,000 and odd. The inquiry officer said that out of 556, 2,10,000 has been sold by the department as a damage which has to be deducted from the charge.
We are not on merits. Cannot as an appellate.
No, what I am saying, that part of the charge was disproved. If you are saying that yes, you are still guilty for 556, a tentative ground has to be given, my lord.
We are not on merits. Sorry, don't ask us to say on merit. Any legal issue?
My lords, only submission would be that, my lords, when you have held me guilty of the entire 556, and in inquiry, when the inquiry officer has held that out of
Have you seen the decision of the Apex Court, Guneshekar, and latest Umesh?
my lord, PNB and
Writ courts cannot interfere on merits.
not on merits, my lord.
You are saying on merits only.
Only I am saying that if you are differing with the inquiry report, that the inquiry report had exonerated on you part of the charges, then a tentative ground for differing ought to have been given, my lord.
Sir, but you have surrendered with reference to fresh charge memo. You can't go back to the earlier inquiry that I have exonerated.
In the second inquiry report, there is no finding regarding that 556, my lords. There is no finding regarding 556.
The
Second inquiry report.
second inquiry, there is no reference to.
550 earlier charge.
Then why are you saying all those things?
Lord, in the second inquiry, there is no reference to the charge which has already been examined. It was in respect of fresh charges.
We need not go into that.
Okay.
Because you are not challenged the charge memo timely.
My lord, then these are the submissions that, my lords, there is a violation of natural justice. I was not provided an opportunity to cross-examine them. And documents, I have repeatedly been asking that they have not been supplied. And the third is, my lord,
Where is the material that you have demanded the document?
my lords, yes, my lords. The report of the inquiry officer itself, my lords, the report I have asked.
Inquiry report not given.
No, inquiry report. Not,
Where is the demanded documents?
my lords. That is, my lords, at page 28, annexure 28, 122.
Page 122. Page 122.
My lords. No. 22/9/2004 letter, my lords. And one more important thing, my lord.
Sir, where is that?
My lord, at page 123, my lord.
Which are the documents demanded by you?
My lord,
Are those documents are relevant for the purpose of inquiry?
relied upon were never supplied in course of inquiry.
Which are the documents relied on?
My lord,
Can't vaguely make statement. All the documents relied. ABCD, the title document dated so and so.
my lord, my lord has, my lord, seen annexure 34, my lords. In annexure 34, which is the second so-called notice, second charge memo, my lord, no document is reflected, my lords. Therefore, my lord, I asked for the supply of all the documents which were.
Where is the regulation which requires documents is required to be furnished?
Yes, this is the rule
Which
which
rule is applicable?
Discipline rules, Malo. Bihar
See that rule.
Several times, Malo direct to the petitioner to appear before the authority to collect the records, Malo. You want
So was the regulation.
Malo. बिहार से इसको मिशन को ये बना के दिए थे ये सब हाँ ये सब मोटा बना के दिए थे
My lord, it may be passed over. I may also see the rule which he is saying relying upon. Just for one day.
How many years matter is pending?
Several times direct to the petitioner to appear before the authority and collect the documents, my lord. But petitioner never.
There are the regulation, Mr. You are representing.
My lord. Revolution earlier, my lord, already submitted, my lord. And again, my lord.
Without books and regulations, you people appear.
नहीं कल हम आपको all documents supplied at the time of charge sheet, memo of charge, my lord.
फर्स्ट इंक्वायरी करें तो बोल रहे हैं कि देखेंगे
नहीं
नहीं
नहीं आपको चार्ज के साथ चार्ज नोट करते हैं जो नवासी ने दिए थे
What do you say?
My lord, at the time of charge, my lord, all documents, my lord, served along with memo of charge, my lord, page 74.
24. Writ petition.
Annexure 8, my lord, memo of charge 71, my lord, and evidence list, my lord, 74, along with memo of charge, my lord, 74. And Krishna's first time demand, my lord, 2004, again, my lord, 2004.
That is
24 is pleading.
pre.
74, my lord.
74.
My lord, 74.
That was
71
first round.
say
my
start
lord.
hazard, 71 say start memo of charge, and list
That
of evidence, my lord, 74.
That my lord said I will not see because it's the first round of.
Page number 17, and where is the list of documents and witnesses?
74, my lord, 74.
Page 17, sir, 6/11/2003, charge memo. You are pointing out earlier.
He is pointing out.
We are concerned with the 6/11/2003. Please apply your mind.
My lord, and second, my lord, page 133, my lord, can you see, my lord? 133. 133, my lord.
What is this 133?
Already mentioned by inquiry report, petitioners wanting some documents, my lord. Already stated, श्री बालक ने अपने आवेदन दिनांक 22/9/2004 द्वारा सूचित किया है.
Now, what is this document, first of all?
Documents, my lord. Thereafter, my lord. No, any specific, my lord. Only for documents.
Sir, what is this document you are relying on? It is titled as what? Inquiry report or what is that?
My lord, detailed inquiry.
Very difficult to convince you people, sir.
Inquiry report, annexure 21.
Sir, we are not concerned with the inquiry report.
The order of dismissal.
Where is the list of documents?
List of documents, my lord, page 74, my lord.
It is relating to earlier.
Earlier name of charge, my lord.
We are not concerned. Why are you going back? When you have already framed fresh charges on 6/11/2003.
Second one. कितना पेज होगा? 4 second charge. My lord, that document not annexed in the repetition, my lord.
Yes.
What was the post held by him?
Assistant godown manager.
Assistant Godavan.
Manager.
He has followed the Godavan itself.
No, my lords.
Sir, in the year 2003, allegation is relating to lakhs of rupees.
No, my lord. Allegation is
77, 78, 1,37,000.
yes, my lord. That was for the period when allegation is that these food grain got damaged, and as a result, it is alleged that it will amount to misappropriation. This is the charge. It was wheeled. It was not properly killed. Our case was that roof was leaking, and it was waterlogged area. This is what we have, and on our instance, my lord, the inquiry started. We made the complaint that roof was leaking. For last several months, we made a report to the higher authorities that, and therefore, my lord, some of the products were sold in open market. An amount of 2,10,000 was realized out of those which damaged product, my lords. It is not a case of selling the product. It is a case where it got damaged. Wild. This is what they use. They use the word wild.
It has damages. We don't know. You are not the witness. We are not.
No, nobody. This is the charge, my lord.
Yes.
Lord, no witness was in the second inquiry. No witness was examined. Only written statement was taken on record.
That point, my lord, never raised my lord file application before the inquiry report, my lord. Only my lord, page 124, my lord, application.
Will convert the penalty from dismissal to that of compulsory retirement. Let him go. Take down in the instant petition. Petitioner has prayed for the following relief. The petitioner, while working as a assistant godown clerk or what is that?
Manager, my lord. Assistant.
Godown manager. He was subjected to subjected to disciplinary proceedings. It was concluded in dismissal on 20th July 1996 and it was subject matter of litigation before this court in CWJC 5568 of 2000. It was dismissed. Thereafter, LPA 778 of 2000 was also dismissed. Further, he has invoked remedy before the apex court in civil appeal number 1941 of 2000 and it was allowed while restoring LPA 1078 of 2000. How can it be 1078? LPA 778
778. It is 778.
778 or 1078?
Just my lord, 1 minute. 20 next to 24. Lord, it is 1078. 1078 is the correct number.
So to the LPA 1078 of 2000. And LPA was allowed on 29/9/2003. Petitioner was taken back to duty on 5/11/2003. The concerned authority, next one, concerned authority, instead of implementing the order passed in LPA 1078 of 2000 to the extent that examination of inquiry report by the disciplinary authority and proceeded to pass order, the respondents have resorted to issuing of fresh charge memo on 6/11/2003. So, the petitioner, instead of questioning the validity of charge memo or invoking contempt proceedings, he has surrendered his right before the inquiring authority insofar as facing a fresh charge memo dated 6/11/2003. Second inquiry was concluded in imposition of penalty of dismissal from service on 22/7/2005. Hence, they present a writ petition. Next, for learned counsel for the petitioner submitted that along with the charge memo dated 6/11/2003, statement of imputation, list of documents and list of witnesses have not been provided. And further, he had demanded certain documents which were also not provided. So, further submitted that About 4 witnesses have been a written statement has been taken by the inquiring officer without there being summoning them to appear in the inquiry and adduce the evidence. He submitted that all of the documents were required to be examined and cross-examined. On the other hand, evidence of the witnesses have been taken note of in the absence of providing opportunity of cross-examining such of those witnesses. Therefore, the impugned order of dismissal is liable to be set aside. So, per contra, and counsel for the respondent resisted the aforesaid contentions and submitted that there are serious charges leveled against the petitioner, and it involves financial irregularities. Therefore, imposition of penalty of dismissal need not be interfered, since disciplinary authority has followed the Bihar State Food and Civil Supplies Corporation Service Conduct and Disciplinary Rules 2001. He also submitted that Rule 28 procedure for dealing with the case of misconduct has been strictly followed. Heard the land councils for the respective parties. Matter is of the year 2005. It is to be noted that this is second round litigation with respect of alleged charges. The first inquiry was commenced on 17/1/1989 and it was concluded in imposition of penalty of dismissal on 20th July 1996. In other words, 7 years has been availed by the disciplinary authority to initiate and conclude the inquiry. Thereafter, it was subject matter of litigation on judicial side, and it has attained finality while remanding the matter on 29/9/2003. The disciplinary authority has committed glaring error in not implementing the order dated 29/9/2003 passed in LPA 1078 of 2000. In fact, he has committed contempt of court order. However, it was not brought to the notice of this court by either of the parties. On the other hand, disciplinary authority proceeded to reinstate the petitioner on 5/11/2003 and proceeded to frame fresh charges, and it was concluded frame charges on 6/11/2003 and it was concluded in imposition of penalty of dismissal on 22/7/2005. It is a case for remand for the reasons that charge memo dated 6/11/2003 was not supported by statement of imputation, list of documents and list of witnesses, and further demanded documents on behalf of the petitioner were not provided to him, and further about 4 witnesses have been examined by means of obtaining written statement from them in the absence of their appearance in the inquiry and providing opportunity of cross-examination by the petitioner. These are all, once again, the authority has committed error. In the light of these facts and circumstances, instead of remanding the matter, this court believes that in order to render justice, modifying the penalty of dismissal to that of compulsory retirement with effect from 27/2005, the date on which petitioner was dismissed from service. No doubt, this court has no power to modify the penalty in the light of apex court decision. However, conscience of this court is shocking to the extent that disciplinary authority has committed blunder, committed glaring error in not implementing the order of this court passed in LPA 1078 of 2000 dated 29/9/2003. On the other hand, proceeded to issue fresh charge memo and concluded during the intervening period from 6/11/2003 to 22/7/2005. Therefore, it is a case for modification of penalty. Instead of remanding the matter to the disciplinary authority and asking him to revisit to the entire matter and once again commencing the inquiry from the defective stage, like providing list of statement of imputation, list of documents and list of witnesses, along with the fresh charge memo, which were issued on 6/11/2003. Accordingly, impugned order of dismissal is dismissal dated 22/7/2005 is modified to that of compulsory retirement. The effect from 22/7/2005. The concerned official respondents are hereby directed to extend all monetary benefits which were due to the petitioner with reference to imposition of penalty of compulsory retirement with effect from 22/7/2005. Monetary benefits shall be calculated and disbursed in accordance with law within a period of 3 months from the date of receipt of this order, failing which the petitioner is entitled to litigation cost. It is quantified at ₹25,000.
My lord. Petitioner retired, my lord, Jharkhand, Hazaribagh, my lord. That time, my lord, petitioner posted, my lord, 22/7/2005, my lord, 5/11/2003 to
22/7/2005, what?
Hazaribagh, my lord, Jharkhand, my lord.
Jharkhand.
my lord.
That order is relating to Jharkhand.
Order passed by my
Order has
lord
been
in
passed
BSSC,
from
Bihar
State Patna office.
My lord.
It was
not
a
happened,
unified,
my
it
lord.
was bifurcation.
All right, but ultimately the Patna office is required to settle his service benefit.
Lords.
What is the
Only for monetary benefit as per bifurcation order, my lord.
only monetary benefits?
14/11/2000, my lord. Those employees are posted in the Jharkhand jurisdiction, then all monetary benefit paid by the Jharkhand. After 2000, my lord. Before 2000, my lord,
All right, you pass such order.
issue already decided by the Human Rights Commission case, my lord.
Huh?
Issue already decided by Human Rights case, my lord, or order.
In terms of that, you proceed to pass order. Whatever the benefit which is required to be given by Patna office, you give it. Insofar as other issues are concerned, you write a letter to the counterpart.